I'll start by just saying that it's great to have everybody participating in this. Obviously, the law in this area has changed so fast and furious that we're all doing our very best to keep up. One of the things for this program that Jennifer Lee, Commissioner Lee, and I decided to do was to just field some questions on the assumption that you folks have already tried to read AB 3088 and the Contra Costa County Ordinance and the CDC moratorium. So those are the three primary laws that we're going to be talking about today. And I know a lot of people had questions about, well, does CDC even apply, and so on and so forth. So what we thought we would do is we would just take the questions one at a time from the list that Theresa provided to us beforehand. But again, feel free to add more questions into the chat. And we have a good full hour to do this. We'll have a hard stop at 1:15 so we can get back to court at 1:30. So I'll just get it going with the first question on our list is, do the commissioners believe the order issued by the Center for Disease Control effective September 4th, let's call it the CDC order, applies to cases in California? The short answer is, and I know you're going to hate this, it's on a case-by-case basis. The CDC order does have broad application, but so does AB 3088 and 2020-26. If you're representing a landlord and you're filing anything right now, you're going to be filing your documents with the mandatory form UD 101. The mandatory form UD 101 is a fairly comprehensive and easy place to note whether your case is going to include both the CDC moratorium and the other laws that we are dealing with. But it is on a case-by-case basis. And I would just add that the major distinction between the CDC declaration of hardship versus what's required now by the state is that the landlord does not have to provide notice to the tenant of the CDC moratorium. So, and of course it includes different required disclosures. Each declaration is different. But at the very outset, it's not a mandatory requirement on the burden of the landlord to provide that to the tenant. So that's what I'll say about that. Jennifer, Commissioner Lee, you want to take the next one?
Sure. Again, pardon my eating. Every officer showed up in Walnut Creek today for traffic, so it was a bit chaotic. I appreciate everyone participating in this program. It's also a great way for Commissioner Dashman and I to go over some of the issues that are coming up, because a lot of this, and to be quite honest, is ripe for litigation. So there are some ambiguities that are built into the code or built into this. The next question we had was, if a tenant submits a declaration in compliance with the CDC order, will the commissioners allow the landlord to question the tenant regarding the truthfulness of the declaration, i.e. whether they fall within its protection? In reviewing the CDC declaration that has to be submitted by the tenant, we could not find anything in there that strictly prohibited it. Now, AB 3088, which does provide in some instances stronger protections, which may make the CDC inapplicable, does not allow the tenant to be questioned unless they fall under that high income earner exception. We submitted, and I believe that Theresa emailed out a copy of the CDC declaration. It may also depend on what they're alleging as why they fall under that. So if, for example, it's not a payment of rent issue, but it is the inability to find housing or whatever one of the declarations is, it may afford questioning. It's definitely going to be on a case-by-case basis, but there's nothing in it, in that ordinance, that specifically precludes it. It's just whether or not is the basis for it something that would fall under the protection of AB 3088, and if it does, then probably not.
So question 3 that we got is related, so I won't repeat. But again, just to emphasize on what is permitted by landlord council is really only to inquire of the high income earners. That's going to be the way that we're going to approach these for the most part. If you want to inquire into the tenants' veracity and truthfulness in making the declaration, you can do so if you're a landlord's counsel by introducing other forms of evidence, but not testimony from the tenant. So if you have information on a rental application, say submitted wage documentation or proof of income in a rental application, for example, or other places, then that can be brought into the evidence, but not, you cannot query the tenant for the information.
Although, just one caveat, I was just thinking,
Go for it.
if that is introduced and the tenant then starts to assert a position, that may open the door for some questioning. So it just depends on the circumstances, because since that, but again, that's on a case-by-case basis.
All right, you're on 4.
Oh, 4, thank you. The Housing Authority of Contra Costa County is governed by federal regulations that adjust rent based on the tenant's household income. Some tenants have quit paying rent because they believe they cannot be evicted for non-payment of rent. This jeopardizes federal funding for Housing Authority. Do the commissioners believe that the CDC order and or COVID-19 Tenant Relief Act of 2020 applies to Housing Authority tenants in light of the fact that these tenants can get a reduction in the rent proportionate to any decrease in income? Neither the CDC order nor AB 3088 excludes the housing department tenants. If you review the CDC form, one of the declaration on the CDC form, one of the specific questions is that they haven't been able to find government assistance and that they've made an effort, which seems to say that if you have the ability to receive government assistance for housing, you may not be eligible under the CDC guidelines because that's built right in. And it is a requirement that the person attempt because of that very reason. So I didn't see any specific language that precluded the Housing Authority. The CARES Act expired. So the Housing Authority is no longer precluded under the CARES Act. I don't know if a new stimulus bill that's, who knows if that's ever even going to pass, if that's going to include something akin to the CARES Act, but at this point, we didn't see anything that precluded the Housing Authority.
The next question is a slightly similar to the very first one, which is how does the CDC moratorium play with AB 3088 in terms of is it greater protections or is it fewer protections, and does our county ordinance apply? And again, we're just going to be looking at these issues on a case-by-case basis. Certainly some aspects of the CDC order seem broader, but then if you look at the ordinance and the restrictions there, which deal with just cause evictions that have nothing to do with rent, you could make the argument that the county ordinance is stronger. So again, it's a case-by-case basis on that.
The next question was on March 27th, Governor Newsom issued Executive Order N3027, which extends the timeline for a tenant to an eviction complaint from 5 days to 60 days if the reason for the eviction is non-payment because of issues related to COVID. Does the time, that extended time, still apply to residential evictions in Contra Costa? What about commercial evictions? That order was part of the California rules of the Emergency Rule 1 and was not incorporated into AB 3088. The timelines have changed. It's not a 3-day notice to pay or quit. It's now 15 days. But because of all the documentation and the paperwork and the affidavits and whatnot. But there was nothing in 3088 that required, that extended it back to 60 days. So the answer would now be like on a non-payment of rent, or would be 15 days instead of 60.
Right. The question 7 deals with the AB. The AB 38 requires landlords to send in an informational notice to any residents who have not paid one or more rental payments that came due between March 1st, 2020 and August 31st, 2020. If the landlord fails to send the informational notice on time, was served after September 30th, can that be used as a defense to an unlawful detainer, assuming it can proceed on one of the narrow grounds permitted under 2020, what will now be called 2026. So any attempt at offering an affirmative defense by a tenant will be entertained by the court on a case-by-case basis. Is it an affirmative defense to a non-payment case? Is it an affirmative defense to a just cause, no fault case? I mean, it's all going to just depend on what the tenant's argument is in connection with not. Obviously, it has nothing to do with non-payment, then it's not going to be an affirmative defense. So we have to look at the case in its entirety. And I just want to emphasize again about UD 101, because I saw in the chat room, Mr. McReynolds put the link out there for every single case that you're seeking, landlord, counselor, landlord is seeking any action on by the court, UD 101 is required. Not just when you file your summons and complaint, any action, including stipulated judgments that are arising out of pre-COVID cases, pre-March 1, 2020 cases. Please file the UD 101. If you don't, it's going to get kicked back. And it needs to be filled out and completely. So just a reminder on that.
All right. The next one was AB 3088 applies to tenants who are natural persons, i.e. it does not apply to corporate rentals. Does Contra Costa Ordinance 2025 have the same limitation? 2025 was just recent, like, what was it, Commissioner Dashman, like a week later?
Yeah, a week after it became 2026.
Yeah, so it's now 2026. We couldn't find anything in 2026, and tenant is not defined in the ordinance, but it is intended to apply to protect the health and safety and welfare of residents in the county. And that would be determined on a case-by-case basis if a corporate tenant qualified under this ordinance.
So we do know that, just to add to that we do know that AB 3088 is broadly applied to any occupancy that does include a residential tenant. So it could allegedly or presumably apply to short-term rental tenants like Airbnb tenants. So generally speaking, I think the broad application is something to keep in mind. Question is, AB 3088 extends just cause protections to all residential evictions through January 31st, 2021. One permitted reason for terminating a tenancy is where the landlord has, at the time the landlord served the tenant with a 60-day notice, entered into a contract for the sale of the property with a buyer who intends to occupy. However, a prerequisite is that the landlord has complied with AB 1482's requirement that the property is exempt from AB 1482 in the form specified by law. If the landlord failed to give the exemption notice by July 1st, 2020, as required by 1482, is this grounds for termination no longer available to the landlord? We read that AB 1482 is mandatory regardless of any application in AB 3088. So if the owner does not provide the required notice, then a single family or home or condo is not exempt from the just cause or rent cap regulations. So, and that's how 1482 has been applied, COVID or not COVID. Ms. Shirley?
All right. The next question is, will tenants have a valid argument that proper notice was not given if the notice to pay rent or quit was not served with the AB 3088 notice and the form declaration of hardship if the landlord opted not to serve the notice to quit because the dwelling is in a jurisdiction that has a more stringent eviction moratorium? This isn't really a yes or no question. It would depend, but AB 3088, if you read it, it was the legislative intent to clear up confusion and inconsistencies between the local ordinances, and it does require adherence to the notice requirements. So, and built into AB 3088 is if that notice isn't served, that that hardship notice isn't served, and an unlawful detainer judgment is entered against a defendant, that would be a ground for them to set it aside under 473 if they file it later. And it could, depending if the testimony was that they were never even served with it, it may be a basis for setting aside that judgment. So this, it does require, and Commissioner Dashman, you can correct me if I'm wrong, but the statute requires compliance with the statute, and if a local ordinance also has additional protections put in, those have to be complied with as well. It's not one or the other.
Right. Well, county ordinance specifically says that it doesn't stand alone. The ordinance needs to be read in conjunction with 3088, and there's actually, you're familiar with 3088's just cause limitation on capital improvement, that provision. So there's nothing spoken about that in the county ordinance at all. So the way to understand how that would apply is simply by looking at 3088 and also looking at the county ordinance side by side. I hope that helps. So if a question is, if a tenant returns a declaration of financial hardship, may that tenant wait until January 31st, 2021 to pay 25% of the transition period rent? Or must that tenant pay 25% of monthly rent each monthly period when the rent becomes due? The answer is the tenant can pay the entire lump sum of 25% of each month at the very end of the transition period. So that would mean that the landlord has to wait until the very last day, which is January 31st, 2021, before it can consider that 25% not paid.
Must a landlord serve the applicable AB 3088 notice and a declaration of hardship for each missed rental period? This one we weren't sure about. If the notice is served without the declaration, then the tenant could possibly argue that the notice is defective. But Commissioner Dashman, what did you think? Because it's not really that clear.
Well, I kind of read this to mean if you have an owner who's going to be doing an eviction based after, say, a third, this is pre-COVID, after 3 months of non-payment of rent. The landlord only serves one notice at the end of that 3-month period, but the notice itself includes each month's unpaid rent in the notice. So I would consider this to be a similar situation where as long as it was served and it clearly identifies the months that are owed, one declaration, one notice would be necessary if it's looking back in time.
I agree, because it would place too much of an onus on the landlord to do it every month. I think that sounds right.
All right, so then we have 13, does AB 3088 afford any protections to a tenant's third-party guarantors, co-signors who do not have a legal right to occupy the rental property? We looked at this and we don't think it does. We don't see any protections stated within AB 3088 intended to protect co-signers or financial obligors that are non-occupants. And that is also true with the county ordinance, although of course, one of the protections that is afforded to tenants in the county ordinance is those tenants who move in a family member who might be sick or needs caring for. Slightly different issue, but that is when you kind of get those non-permanent occupants covered.
And I just want to go back really quickly and clarify something that I said earlier. It's now the 15-day notice to pay or quit. Once the complaint is filed, the answer still has to be filed within 5 days, but the response for the declaration prior to filing of the complaint has to be served by the tenant to the landlord within that 15-day time period. Once the complaint is filed, then the answer is still 5 days. It ameliorated that 60, and I'm sorry if there was any confusion on that. All right. I just realized I said 15 days, and what I meant was 15 days before you can file a complaint, and they have 15 days to respond with the affidavit, the declaration. Okay. Do the protection, you did the, I'm sorry, Commissioner Dashman, you did the one with the third party, correct? I just want to make sure.
Yeah, so you're on 14.
All right. Do the protections only apply to current tenants? For example, is there any requirement to serve notices under AB 3088 to former tenants, assuming their new addresses can be ascertained before proceeding with an action for unlawful detainer or damages? I don't think we were quite sure about this question, because if they're no longer a tenant, it wouldn't be an unlawful detainer. It would just be a limited civil. But if the damages for a 3-day to pay or quit can't be pursued until after February 2021. Landlords can file small claims actions for rent only at any time if it's within the current small claims cap, so under $10,000. If the amount is over $10,000, then that's only allowed beginning March 1st, 2021 and beyond. Case splitting is not allowed. So if you're trying to get under that cap by filing the same cause of action and breaking up the months of rent owed, that won't be accepted.
Yeah, and we can talk a little bit more about the small claims cases, maybe in another one of these, because both Commissioner Lee and I do the small claims calendars in the county. So, but without getting too far sidetracked on small claims, we'll let you know we're willing to do another one of these if we want to do another one. All right. So question is, if a tenant was delinquent on rent before March 1, 2020, do the protections of AB 3088 apply to that tenant? The answer is no. If there's rent owed before March 2020, then, and only before March 1 of 2020, then it's considered a pre-COVID case and it won't apply. The tricky part is when you get overlapping periods. So you have rent owed for February 2020, but you might also have rent owed for March 2020. In that situation, yes, it applies. So your landlord clients and landlords should be very careful about how their notices are drafted when there's potential for overlapping pre-COVID and COVID cases.
If a tenant who was delinquent before March 1st, 2020 starts making monthly payments equal to 25% of the current month's rent during the transition period, would this amount apply to the transition rent period or to the amount due and owing before March 1st, 2020? Due and owing, if you're saying that the tenant has to catch up on past due rent first before exercising the privilege to only pay 25% per month during the transition period. I didn't see anything, I don't know if Commissioner Dashman thinks that anything that would grandfather in the 25% to anything prior to March 1st, specifically because the language of AB3088 says that if a person was guilty, would have been guilty of an unlawful detainer on March 1st, that AB3088 doesn't apply. So it would appear that you would go to back, then prospective.
Okay, so what is the interplay going to be between a landlord bringing a small claims action for unpaid rent versus the normal eviction procedure with a judgment for possession and past due rent? For example, what if the tenant defaults outside the Tenant Protection Act period and the landlord brings an eviction action? Would a judgment in the landlord's favor include all the past due rent, including anything that may have been previously awarded through small claims? A little bit difficult for me to understand what exactly is being asked here, but first of all, if you're going to be seeking past due rent in the UD and not, then it has to be in the form of a small claims action, and that would only be for the COVID cases. Certainly their court isn't going to be allowing landlords to double dip in getting rent in UD cases as well as small claims cases. I think that's what the question asks. Commissioner Lee, do you have a different view?
No, I remember you and I discussed this one, and I think that the way you answered it was the best one we could come up with.
Okay, all right. All right.
All right, let me see. Let me go back to my Word document. All right. The next question was, I've had a lot of inquiries from other attorneys and clients wanting to know if the Fed CDC eviction moratorium applies to owner move-in evictions. The general consensus that it is permitted by the state and county, but the CDC language is somewhat lacking in clarity as to whether it's permitted, and would also be good for them to confirm whether or not it's permitted under the state's current moratorium. Well, once again, if the state provides more protections than the CDC is not going to necessarily apply. The very beginning of the CDC, the declaration says it's for tenants, lessees, or residents of residential properties who are covered on the CDC's order, not including foreclosures on home mortgages to prevent the further spread. Under the CDC's order, the declaration, each adult listed on the lease, rental agreement, or housing contract should complete the form. And then it goes down and it gives but it doesn't specifically preclude. And if you read the CDC order, it doesn't specifically preclude owner move-in, and California allows for that. So again, it'll be on a case-by-case basis to see if it would be applicable.
Right. And if you look at the county ordinance, it also addresses owner move-in evictions in a slightly narrower interpretation than state law. So it would be the county ordinance that would apply in that very unique situation.
All right, and then we had the more questions.
Okay, so then we got more questions. Hope we're all still hanging in there. For evictions other than non-payment, if the tenant poses a health and safety risk, does the landlord still need to submit a declaration when filing the UD complaint? And related to that is, do we need to include the police report, if available, as an exhibit to the complaint? So the health and safety cause, which is permitted under the county ordinance, does not actually say any longer that you're required to provide any declaration. It's just simply another, it's a check the box, it's a no fault, just cause reason. Obviously at trial, the burden of proof and so forth is going to require a showing, but to get the complaint filed, you won't need to have that declaration any longer. And as far as the reference to police report or for instance, any other evidence of health and safety, that would be a matter for trial to prove up your cause.
Will the commissioners review notices and pleadings to make sure requirements are under AB 3088 are met? Yes. Will clerks reject UD complaints without the mandatory cover sheet? They should. They would definitely get kicked back. UD 101 should be filed with any substantive pleading filed now. Will the court dismiss a UD action based on a defective notice if the plaintiff failed to provide defendant with the required notice of tenants' rights under AB 38? Most likely, yes, because the code requires it. I mean, these are built-in, mandatory, it has to be done. But the cases are dismissed without prejudice, but they have to be done. And it's a lot of work, and we understand all that.
Will the court dismiss cases sui sponte, or can the clerk reject a complaint if the plaintiff confirms that the tenant submitted a declaration during the covered periods? I think our practice is that if there's any question, those cases are coming to our attention, and the clerks do have direction to return UD 101s that aren't completed, or return cases where it hasn't been filed in the first place, and that sort of thing. When it gets to some more of the nuanced issues, those are coming to our attention.
And our office is concerned with the safety for unlawful detainer litigants, particularly in Martinez. We found it impossible to comply with social distancing rules because it was so crowded in the hallways that lines doubled back. What measures are the court taking to decrease COVID-19 transmission in the courthouse? Well, the 7th Amendment local rules should be coming out pretty soon. And they're going to deal with telephone appearances as well as Zoom appearances, and dealing with those issues. We are very mindful and conscious of the social distancing requirements. And depending on, it is something that we have talked about trying to, a lot of it has to do with volume and resources. And we're always willing to consider and discuss the necessity of utilizing pro tems, expanding hours, things like that. And we just sort of have to see how this is going to play out at this point in time.
Right. So obviously we're all dealing with an unprecedented situation and are working with what we've got currently in terms of resources to address those. But that things are always subject to change. So the next question is, I think that's it for the questions that I have.
Okay.
There was a couple of other questions that were presented that were, you know, how to advise landlords and tenants in specific situations. So as Theresa said, we're going to keep our seminar today, our question and answer today, mostly on generic issues as opposed to specific fact patterns.
All right. Thank you very much, commissioners. I'm going to put up the poll. For those of you who might have arrived a little bit late, this is just a quick survey. You can answer, there's no wrong answer, but you do need to answer because that's my way of taking attendance today. So you can get your MCLE credit. So we'll do that quickly, and then we're going to go to answering other questions that people have been sending me in the chat. So I have a few so far, and if anybody else has any, please send it to me, but I'm going to launch that poll. There you go.
Hi, Marie.
All right, wonderful. Just leave that up for a minute. And yeah, Carrie, I that's why I put refuse, prefer not to state, because I knew someone like you would say that. So okay, I'll just leave that up for one more second, but I will let the commissioners know. The first question that I had is, many owners just want to sell. Can tenancy be terminated in order to facilitate owner's sale?
That is a good question. I saw something in AB 3088 about that, and I just got to find it. Do you know, Commissioner Dashman, off the top of your head?
Not off the top of my head, no. I think there was something about a bona fide purchase contract or something. But not off.
I can't, yeah, I remember seeing something in there. And let me just see if I can find it. Because I understand why people would want to sell. Oh, here we go. Let's see. It's in AB 3088, and let me just find the right section. It says,
thanks, Maria.
1179.035 before February 2021, a court may not find a tenant guilty of an unlawful detainer unless it finds one of the following applies. And then if you go down to paragraph Roman numeral 2, notwithstanding subclause Roman numeral 1, termination of a tenancy, that's remodeling, the Romanet 3, paragraph Roman numeral 2, Romanet 3, the owner of the property has entered into a contract for sale of that property with a buyer who intends to occupy the property, and all the requirements of paragraph 8 of subdivision E of 1946.2 of the Civil Code has been satisfied. So if it's someone who's going to buy it and then use it, that's different. Oh, thanks, Marie. She found it faster than I did. Thank you.
All right. Do you want me to move on to the next one? Okay, great. Does AB 3088 apply to short-term rentals such as Airbnb? And then another person had asked, how are the AB 3088 protections enforced for lodgers? Do landlords have to file a UD to evict lodgers under 3088?
Well, the first part is yes. It seems the way it's drafted is AB 3088 will apply to short-term rentals. Now, the rebuttable arguments made on that, depending on the facts, but it doesn't eliminate short-term rentals per se. And the other part of the question I didn't get because I didn't understand. I don't know what the word lodger means.
Yeah, that's a good question. Sophia, do you want to unmute yourself?
Yeah, like someone who is renting in an owner occupied unit, like if they're renting a room and the owner also lives in the house.
Oh, kind of like a roommate?
Yeah, because I think 3088 covers those renters, but I wasn't sure how it'd be enforced if landlords would need to file a UD.
I think it does apply.
Yeah, I agree with that. And related to that, it would be like a master tenant situation.
Yeah.
Also would apply to get a
All right.
roommate out.
Okay, thank you. Let's see, what do we have? Can a landlord file an eviction for unpaid rent due before March 2020 and not ask for holdover damage, but only ask for unpaid rent before March and a judgment for possession?
I think the answer to that is yes. And then the related question is, are holdover damages considered past due rent? If the eviction was perfected before March 1st of 2020, then there is some ambiguity. Is the non-paid rent that might continue past March 1st be considered holdover damages and not unpaid rent? And Commissioner Lee and I haven't discussed this between ourselves, and I have some thoughts about that. So I think I'll just reserve the answer on that for now. But that would be the question, and we can give you an answer later.
Okay, great. Next one is, has there been any move to make any of these restrictions applicable to commercial tenants?
2026 just added commercial tenants.
Yeah,
But
so if you take a look at that, they're protected through November 30th of 2020 with requirements.
All right, great. What is the recourse for families that want a family member out of their home? Is there something we do in this county specific to that?
it would still be a UD. And it would, I mean, that's what I would think, because we get that all the time. But it would still be a UD. It could, depending on what the issue is, it could be for a cure or quit. Or if it's a fixed term lease, or I mean, it could be any number of things. I don't know. What do you think, Commissioner Dashman?
Yeah, I think there's nothing new that's written into AB3088 or the ordinance, except for the exception for COVID family members in the no fault just cause provisions of the county ordinance.
I mean, I think this is part of the issue. Is one of the concerns that people have had about these moratoriums or modifications is that in a situation where people can't leave, they're not working or they're working from home, it can cause a lot of strife, and then you're forced to be with that person. So we understand it can create a lot of very difficult and frustrating situations.
Okay. That's it for the questions I have, unless anybody's got a last minute one. Yes, to answer, someone asked about finding the recording later on the website. Yes, it will be up probably next week. I will also, I can send everybody who registered for the program, I can send you the link to it too, once it's ready. if you want to be able to watch it. Commissioners, any other thoughts or words of wisdom that you'd like to send out to everybody?
Well, just to get back to this, since we have a couple minutes, the small claims thing, maybe we can just cover it real
Sure.
quick right now. So we expect to see a lot of small claims cases being filed to collect the $10,000 plus rents. What you'll be seeing then is landlords who want rent. They don't care about attorney's fees because you can't get attorney's fees in small claims, as you all know. And there's no cap on once it over the threshold. There's also apparently no restriction on the number of cases that you can file if you're a landlord, as there is now. You know, if you're a frequent flyer, you can only do so many. You have to cap it at 2,500. That cap seems to be gone for this particular purpose only. So figure that into your plan for next year. We're going to be likely seeing a lot more of those. If your landlords are insisting on collecting their attorney's fees, then they're going to be needing to look to Superior Court for those claims, in the event there's damages that qualify for attorney's fees by contractor statute.
So I had one more question, a clarification. Does 2020-26 require owner move-in to comply with the Ellis Act notice requirements? The time period's longer under the Ellis Act, I guess 120 days.
Commissioner Lee?
I'm just trying to think. So you're asking if the owner move in, if for the under AB 1462, I have to look at that. I don't want to misspeak off the top of my head. And I have to look at the requirements.
Okay,
I don't recall 3088 or the county ordinance addressing that issue.
No, I don't either.
So if nobody else has noticed that it's included, I would say
I didn't
that
see it in there.
the Ellis Act notice period hasn't changed.
Yeah, I don't think it has, because I didn't see it in there. Let me just look really quickly, because I have the act up. I have AB 3088 up. No, I don't see anything in there. Owner move in. Yeah, I'm not finding anything in there.
You can't go wrong by giving more notice though, right?
Exactly. And there are a couple of questions in the chats now.
Yeah. So first one is, are you anticipating utilizing pro tems in the near future to help with the overload of cases?
Well, I think first we have to see if there's going to be an overload. Right now, the calendar hasn't been too crazy because there hasn't been the onslaught of filing. It was originally anticipated, because we didn't know until literally the 11th hour that AB 3088 was going into effect. So we did have a plan if the emergency rule sunsetted and it went back to normal. That didn't happen. And so that's really slowed down a lot of the filings. It hasn't been the floodgate or the flood of cases that we were anticipating. So we just have to see what's going to happen. We try to limit the calendars the best that we can.
Okay, great, thank you. Will the limitation on small claims damages for a non-human entity apply to these cases?
Meaning like commercial?
Yeah, I don't think so for this particular, for this particular type of claim. So in the box where you fill out on the small claims form, you would explain why you're exempt from that requirement. And it should hit our courts if you do that. The form has you'll see when you get into it. There's a space to fill in on the form.
All right, I think that's it. It looks like the other things in the chat are kind of replying about
That was that.
that previous question. Yeah. So, well, if there's nothing else, I would just like to thank you both so much for your time and your expertise. I know that there's been a lot of angst with
Sure,
attorneys
understandably.
and their clients, and you know, it helps to hear from the people who are dealing with all this, to, you know, to clarify as much as I know you can. I know there's some parts that are still sort of unknown, but this was a huge help, and it sounds like we should look at trying to do something like this again, you know, when we get more changes, or if there's, you know, in other areas, I'm seeing head nods and, and things. So,
Well,
yeah.
and the thing is too, this is a whole new area of the law. And we understand that there's going to be rulings that we make based on our interpretation that are going to be ripe for appeal. And the folks in this room are going to be instrumental in creating the interpretations of this law. So we appreciate the patience bearing with us as we navigate through all of this. And as I like to say, thank God for the Court of Appeal. That's how we learn. So it's great.
very true.
So we'll check back in maybe a month and see if we
Mhm.
need to have another one, like an
Great.
update. I
Absolutely.
think that would be certainly enough time would have passed by then to see if we're going to see that, you know, heavy load on the courts by the, you know, the notice periods will have expired and all of that.
Yeah, and I would encourage any of our members, this came about because a member approached me and said, hey, I'd really like to get some more information from the commissioners on this. And, you know, as soon as I mentioned it, they both said, yeah, I'd love to, you know. So please don't hesitate, you know, on this issue or anything else in your practice. If you want, you know, any kind of a program, court related or not, just let us know, and we will, you know, we want to do what you guys need. So please reach out. And one last thing I forgot to say is anybody who called in, I know you were not able to do the poll. So please shoot me an email and let me know who you are and that you participated. And that way I can count you. And it's 1:12 according to my my clock here. So I want to let the commissioners go so they can wolf down a little food before they start court at 1:30. Again, thank you so much. And thank you to everybody who was here today. Have
Thank you
a
so much.
wonderful day, everybody.
Thank you.
Bye.
Take good care.